discrimination.
So associational discrimination.
Yes. So in 2011, the Supreme Court of the United States had a case under the federal discrimination laws that dealt with a fiance of an
Not Beyonce.
Not Beyonce. A woman had filed a sex discrimination charge against the company. 3 days later, the company fires her fiance, who also worked for the company.
Ooh.
So he filed a discrimination case claiming retaliation. So the question was, can you establish a discrimination claim if because you were retaliated against? Because your fiance filed a discrimination claim. The original discrimination was not against the plaintiff, Mr. Thompson, it was against his fiance.
But did he have negative reviews? Already I'm thinking about questions.
Right.
Was he reviewed? Was he put on notice prior? Was
Well,
there any feedback?
Those are all great questions, but the court was just dealing with the narrow principle of whether under federal law he could maintain an action for discrimination based upon this retaliation against the employee who filed the original charge by firing him because of his close relationship to the employee. And what's fairly rare is when you get all of the United States Supreme Court judges agreeing. We've talked about a lot of times cases are decided 5-4. Well, here it was basically 8-0, and the court found, based upon the language of the federal law, that he did have a cause of action if he could prove it.
If he could prove it.
If he could prove it, he's still got to prove it. But basically, that was an interpretation of federal law. So everybody's wondering, well, how does this apply to state law?